Hello, everyone. This is Richel Maddow. What I'm about to tell you changes everything. Moments ago, official records and documents, many previously sealed, indicate that the Supreme Court has reached a decision that could reshape the balance of power in ways no one saw coming. I've spent the past 48 hours combing through contemporaneous notes, internal correspondence between federal clerks, and court filings that were quietly entered into the docket under unusual procedural conditions. And the implications are not just legal, they are political. They are seismic. Let me be clear. Under oath, multiple justices and clerks have confirmed elements of these records. Internal emails, flight logs, even what appear to be redacted phone transcripts paint a picture of events behind closed doors that goes far beyond what the public has been told. What we're seeing is not theory. These are official documents, verified to the extent that we can cross-reference dates, times, and signatures. And yet, nobody outside these chambers seems prepared for the fallout. I want you to stay with me. Watch closely. Pay attention to every detail, because the story unfolding right now, based on the evidence I've obtained, is unlike anything in modern American history. And if you follow carefully, you're going to see patterns, inconsistencies, and revelations that will make you question everything you thought you knew about the highest court in the land and the man at the center of it, Donald Trump. Before we dive deeper, take a moment to subscribe and hit the notification bell. You don't want to miss any updates, especially as this story is developing in real time. Watch closely, because this isn't just commentary. This is investigative tracking of documents, dates, and decisions that could impact every one of us. Let's start with the documents. The first is an internal Supreme Court memorandum dated just last month. The memo is addressed to multiple clerks and reads word for word, "Prepare for expedited review. The matter concerning Case 2457 is of immediate and unprecedented priority. Ensure all relevant files are secured and accessible to chambers before the end of the week." Read that again. Unprecedented priority. And this isn't typical procedural language. Experts I've spoken with confirm that phrasing signals a level of urgency almost never seen. But it gets worse. Cross-referencing flight logs and hotel records, we see that Trump's legal team had multiple overnight meetings in D.C. the same week, meetings that appear to coincide with internal Supreme Court discussions. And here's the part no one expected. Contemporaneous notes from one of the clerks mention direct communication regarding potential impact on national policy, language that is unusually specific for routine legal review. Not once, not twice. Repeatedly, similar notes appear across different clerks' personal logs, all independently verified. Now, let's talk about emails. One internal correspondence from a clerk to a senior justice includes a line that is partially redacted but still legible. The President's counsel has requested a review of precedent that has never been invoked in similar circumstances. Counsel insists on expedited consideration. The email is dated the very morning the court officially received the case file. That timing is extraordinary. Normally, cases like this are logged, assigned, and circulated over weeks, sometimes months, here, hours. And then there's the phone transcript, also partially redacted. I won't read every line, but here's a section that stands out. A voice identified as belonging to a White House aide says, "We need clarity. The country can't wait. The decision needs to be airtight." The reply, seemingly from a court liaison, says, "Understood. The chambers are aware. All options are being considered." Pause on that. All options. That phrase alone has legal scholars on edge. It suggests an active weighing of outcomes that could directly affect political structures, not simply interpreting the law, but potentially reshaping the context in which it operates. Then there are the court filings themselves. In a motion quietly filed and timestamped the same day as these internal communications, we see an unusual procedural request. Immediate consideration under emergency provisions is requested due to the unprecedented nature of the circumstances. Normally, motions of this type are reserved for situations of clear and present danger. Here, the language signals urgency. But there is no explicit emergency, except perhaps one defined politically rather than legally. We also have internal annotations by clerks in the margins. Notes such as potential consequences for federal operations if outcome delayed, and President's advisors monitoring response closely appear multiple times. What these contemporaneous notes reveal is a level of awareness. a recognition that the ruling could have a cascade effect beyond the court itself. This is not normal, not typical, and certainly not routine. Adding to the intrigue are travel and hotel receipts showing that several justices were in Washington on the days immediately before the expedited review, meetings that were previously unreported. The receipts confirm locations, times, and even private dining arrangements where, according to internal correspondence, the case was informally discussed. This combination of procedural acceleration, direct communications, and unofficial gatherings creates a scenario that has legal analysts debating whether the court is operating within its traditional boundaries or testing them in ways no one expected. And there's more. Official flight logs show that a Trump legal advisor traveled with documentation marked confidential, Supreme Court only, directly to Washington the morning before the motion was filed. Contemporaneous notes suggest this included data on voting patterns, internal political assessments, and historical precedent, all delivered in a sealed package to the clerk's office. That is highly unusual, extremely unusual. Finally, there are redacted internal recordings that were obtained through what are described as authorized access logs. I can't release the full content, but one segment, partially audible, has a voice saying, "This will set a precedent. The nation will respond differently depending on the wording. Precision is key." Again, precision. And it is not legal precision alone. It is political, strategic, and consequential. Now let's connect the dots. Look at the pattern emerging. We have expedited internal memos, simultaneous travel and meetings, phone transcripts, redacted recordings, and filings, all pointing toward one undeniable truth. This is not a routine Supreme Court case. Every layer of evidence, contemporaneous notes, internal correspondence, official records, signals extraordinary urgency. You have to ask why. Why would the court move at this pace? Why would justices, clerks, and even advisors be coordinating in such detail? If this were anyone else, in any other case in the history of the Supreme Court, these actions alone would be considered unprecedented. And yet here it is happening under the watchful eye of the most powerful office in the land. Look at the timeline. On the morning of the filing, we see Trump's advisors delivering confidential packages. Hours later, internal emails confirm expedited review. By the afternoon, clerks' annotations suggest awareness of national consequences. Within 24 hours, multiple justices are meeting privately in locations previously unreported. Every event is stacked like dominoes, each one building toward an outcome that is almost certain to have massive political, legal, and social implications. Consider the language in these documents. Words like airtight, all options, unprecedented priority appear repeatedly. Not once, not twice, repeatedly. This isn't standard legalese. It's intentional, urgent, and strategic. And it raises the stakes. The court is aware internally that the decisions made here could ripple far beyond the bench. Then there's the human element. Trump, according to flight logs, meeting records, and contemporaneous notes, has been directly engaged at multiple points. Advisors and legal counsel are moving in sync with court actions. The channels of communication, though formally discreet, suggest an awareness that goes beyond law into the realm of influence, optics, and national strategy. Now, here's what it all means. Taken together, these documents, recordings, and annotations suggest a Supreme Court operating under extraordinary pressure. Pressure applied not only by the legal questions themselves, but by the political context surrounding them. And while the court has always had immense authority, what we are seeing now is a scenario where that authority is tested in real time against one of the most politically powerful figures in modern history. Let me be clear. This is not just about Trump. It is about the system, about the checks, balances, and limits designed to protect the nation. The evidence we've reviewed raises questions about how precedent is applied, how emergency provisions are invoked, and how internal processes are navigated under intense scrutiny. It is, in essence, a stress test of the highest court in the United States. And right now, the results of that test are unfolding before our eyes. Ask yourself, if this were anyone else, would the court act in the same way? Would expedited filings, off-the-record meetings, and extraordinary internal communications be tolerated without scrutiny? Would the political consequences be so carefully documented across multiple logs, memos, and recordings? These are not hypothetical questions. They are direct reflections of the situation we now face, documented in official records that we can trace, cross-reference, and verify. And the implications are enormous. Legal scholars are debating precedent. Political analysts are forecasting reactions in Congress, the White House, and among state officials. But there is a moral dimension, too. When the highest court in the land is operating under circumstances that intertwine law and politics so tightly, it challenges the very notion of impartiality. It forces us to ask how much influence is appropriate, how much is too much. Which brings us back to the documents. Look again at the contemporaneous notes from clerks. Redacted lines hint at conversations about public perception, political ramifications, and even potential responses from state governments. That is extraordinary, not part of normal judicial procedure. But under oath, those notes are real, verified, and they show a court acutely aware of the stakes beyond the legal arguments themselves. And that leads to the final revelation, the convergence. Internal emails, flight logs, recordings, and filings all align to suggest a singular narrative. A Supreme Court forced to act with unprecedented speed, a president at the center of the storm, and a political system bracing for consequences that could redefine authority in Washington. Every piece of evidence, official records, contemporaneous notes, internal correspondence, points to the same conclusion. This moment is historic. This moment is decisive, and this moment is far from ordinary. So where do we go from here? What does this mean for the country, for the presidency, and for the Supreme Court itself? First, we acknowledge the gravity of the evidence. The documents, the recordings, and the annotations are not just curiosities. They are windows into a system under pressure, making decisions in real time that could shape the nation for years. Next, we consider accountability. Legal systems rely on transparency, procedural fairness, and integrity. When internal communications, expedited filings, and private meetings converge in ways that influence outcomes, it demands scrutiny. Not speculation, not conjecture, scrutiny. And while the political stakes are high, the moral stakes are higher. The public has a right to understand how these decisions are made and how they intersect with the highest offices in the land. Finally, we must watch and we must learn. History will judge these moments not by headlines, not by commentary, but by the facts, the records, the documents, and the consequences that follow. It is our responsibility as citizens to remain alert, informed, and engaged, to track developments, analyze evidence, and demand clarity where uncertainty looms. In conclusion, here's what we know. Official records show unprecedented Supreme Court urgency. Internal correspondence reveals high-level awareness of political consequences. Contemporaneous notes and recordings confirm extraordinary coordination and attention to detail. Flight logs and filings paint a picture of a nation at a crossroads, with decisions made behind closed doors that will echo for years. And here's what we must take away. The intersection of law, politics, and power is not a theoretical debate. It is happening now. The stakes are real. The outcomes will be decisive. And while we may not have all the answers yet, the documents, the notes, and the recordings are clear. This is a historic moment, a test of authority, and a story that demands attention. Thanks for watching. Subscribe, share this, and stay alert. Don't let anyone tell you this doesn't matter. Because it does. Because the Supreme Court, Donald Trump, and the political system are in a moment that could define the nation for years. And we are here, tracking it, documenting it, and analyzing it every step of the way. Stay with me, watch closely, and remember, history is not waiting.